Welcome to Transnational Competition Law course, and dear learner and viewer, we have discussed with you the extraterritorial application of competition remedies in European Union, and we have noticed the fact that the European Union happens to be incorporate a history of more than 75 years of advancement of competition remedies, which started from Article 85 and 86 of European Economic Community Treaty. Later on, it has been re-christened as Article 101 and 102 on the Treaty on the Functioning of European Union 2010. Besides that, we find that in 1962, the Council of European Union adopted a council regulation which have given effect to the rules of application under Article 85 and 86 of the European Economic Community Treaty. And more than 50 years of its functioning, we have seen the advancement of the competition remedies. So, the primary law relating to the competition remedy happens to be the European Council Regulation of 2003, Article 81 and 82, Article 101 and 102 of the TEFU, which prohibits all kinds of the anti-competitive practices and the antitrust violations and advancement of remedies. With that, Article 7 is very important, which Article 7 of the European Council regulation, which empowers on the Commission to impose any kind of the behavioral and structural remedies, which we have seen in the last lectures and we have discussed in a detail. We have also discussed the salient features of the European Commission Notice on Remedies 2004 as to how Article 6 and Article 8 of the European Commission regulation happens to bifurcate the entire notion of the remedies under the merger regulations and the concentration regulations, and thereby what we see that a mixed bag of the merger regulation and the implementation regulation, which has been advanced by the European Council, Economic Council, happens to advance the competition remedies in European Union. We've also taken note of Article 7, Section 2A, Section 2B, Section 3A, Section 3B, and today we are going to discuss in a very broader framework what you call that what is the nature and extent of the competition remedy in European Union. In that reference, dear learner and viewer, what we will see that the Treaty on the Functioning of the European Union 2010, which tries to see that the competition remedies must based on certain examples, or certain examples happens to be that the European Union have developed a kind of a parallel enforcement system and the antitrust rule. The first is the European Commission, then the College of Commissions are there, and the College of Commissions through European Competition Network and the advisory committee tries to see the entire cases of the violation. If we look at the very functioning of the European Union's antitrust rule in matters of advancement of the competition remedy, what we find that the European Commission as an apex body consists of the College of Commissions, consists of the Commissioner for Competition, and then the role of the Commissioner of the Competition happens to inform and support, and then it tries to work through the Director General and other director superintendents and the other deputy directors. They consult, they try to provide some kind of advice, and then only it was referred to the advisory committee, and the advisory committee goes into the merits of the case, and then the European Competition Network comes into play, and the National Competition Authority and their members taken together happens to provide the competition remedies. And if it goes to the court of law, then the national courts and as well as the EU courts happens to see the entire dimensions of the competition remedies. Here, what we find that in matters of the advancement of the competition remedies, it tries to see two kinds of the remedies. The one is the implementation remedies, another is the merger remedies. And in that respect, we see that the entire College of Commission, the Directorate, and the enforcement of the competition remedies work in tandem with the courts and the advisory councils. And in that reference, what is important to see that as we have seen some of the salient features of the 2004 European Commission notice on remedies, which have two sets of the remedies. The one is the merger regulation, and another happens to be the implementing regulations. And taking together the merger regulation of 2004 and the implementation regulation of 2004, we can see the very nature, extent, and the content of the remedy which has been provided under the European Union. And for that matter, the Article 7 of the European Commission Regulation 2003 again become very important. And it is nothing but incumbent on us to look at the Section 2A, Section 2B, Section 3A, Section 3B, which tries to see that what are the aims and objective of the remedies, what are the effectiveness, proportionality, and the remedial link, what is the designing of and monitoring of the general remedies, and what is the designing and monitoring of the general remedies in digital market. And then section 3C and 3D directly devoted to the remedial process, that whether it is iterative or non-iterative. With that, we see that the entire approach of the European competition remedy, which moves from modernization and decentralization reform, needs to be understood not only in the context of Article 7.1 of the European Council regulation, and not only in reference to the European Commission Notice on Remedies 2004, but we have to equally see again as to what constitute the 2004 European Union's Commission Notice on Remedies, and to what extent the European Commission Notice on Remedies 2004 happens to be very successful. The story goes like this, that the European Commission published the new notice on the remedies under the merger control regulations of 2008, whereby it tries to see the entire canvas of the competition remedies from a very new perspective and a fresh perspective. And that perspective happens to be that the competition published some amendment to the implementation regulation and as well as the merger regulation. So from that point of view, we see that the implementation regulation have undergone to some kind of a metamorphosis, which has been implemented through the competition notice on remedies in 2004, and thus we have to look the entire implementation regulation and the merger regulation handed down by the European Commission's notice on remedies in 2004 from a different perspective, and that perspective can only be provided what we call that the perspective relating to 2008, and it is nothing but essential for us to look at what is the general principles which has been underpinned into 2008 remedies notice. So what we see that under the merger and control regulation, and the merging parties are allowed to modify a concentration that raises the competition issues to obtain commission's clearance for the transactions under the new modified 2008 European Commission's Notice on Remedies 2008. Such modifications are commonly known as remedies, since their object is to eliminate the competition concern identified by the Commission. The merging parties may modify a proposal concentration either before or after the modification of the Commission. Thus, the European Commission Notice on Remedies 2008 substantially revises the previous Commission's Notice on Remedies of 2001 and 2004 but it does not change much with respect to the Commission's current practices. Rather, the new notice or the European Union's Commission notice of 2008 try to codify the existing practice and reflect the Commission's evolution of experiences with assessing, with accepting, with implementing remedies, and it has taken recourse to some of the judgment of the European Court of Justice in relation to the merger regulations which has been handed down by the European Union's Commission notice of 2004. With this, we will try to see that as to how that European Union's Commission's notice on competition remedies 2008 happens to subscribe the general principles through the general principle of the European Union Commission notice on the competition remedies 2008 tries to propose and implement the general requirement, and among the general requirement what is required that the notice reconfirms the general requirement must be fulfilled for proposed remedies to lead approval of the modified transactions. The remedies must eliminate competition concerns in the entirety. So the 2008 remedy strike directly that it must eliminate the competition concerns in the entirety. It should be comprehensive and as well as effective and capable of being implemented effectively within the short period of time. It means in an expeditious manner. The other general principle was uh, introduced or was envisaged under the European Union Commission's notice on competition remedies in 2008 happens to be the proportionality of the remedies and the Commission's preference for devastator remedies. And then here the Commission under the 2008 notification on the competition remedies reconfirms its responsibility to show that a concentration would be significantly impede competition. Thereby, it cannot impose unilaterally any kind of a condition to clear a transaction. Rather, it believes that it is for the parties to propose remedies adequate to eliminate the competition concerns. And in that reference, if the parties fails to do so, the only option for the Commission is to adopt a prohibition decision. So this is a broad general guidelines in relation to the European Commission's notice on competition remedies 2008. And then what we see that the European Commission's regulation on competition remedies 2008 try to regulate or try to play a very crucial role in ensuring fair competition and safeguarding the interest of the consumer and business within European Union's single market of 27 countries. Thus, we see that the overall and the overview of the European Commission's regulation on competition remedies 2008 tries to focus and try to review the broader context of the competition regulation within the European Union, and the European Union which places a strong emphasis on promoting competition as a means to foster innovation and efficiency and the consumer welfare. That objective must be realized through the instrumentality of European Commission regulation on competition remedies 2008. And to that end and to achieve that goal, the European Union has established a comprehensive framework for competition rule enforced primarily by the European Commission, and the key objectives of the European Commission regulation on competition remedies 2008 happens to be to focus on to focus and design a specific challenges, that is to ensure effective competition within the European Union as a single market, and what it primarily try to focus is the fact that it number one, it tries to prevent anti-competitive practices and anti-competitive behavior, be that the cartel, be that the dominance of the market position or anti-competitive merger and acquisition. Secondly, it tries to ensure market access and fair competition, and it seeks to promote market access for a new entrant and smaller businesses by removing barriers to competition and ensuring it try to ensure market access and the fair competition, and how it can promote the market access for new entrants and the smaller businesses. It can only be possible by removing the barriers to competition and ensuring level playing field to all market participants. And thirdly, the European Commission's notification on competition remedies 2008 tried to safeguard and protect the consumer interest, and the regulation directly aims that fostering competitive market which can lead to lower prices, greater choice, high quality product and services are something that will go for the protection and safeguarding to the consumer interest. Thus, we can just again call out what are the main provisions of the European Commission's notification on the competition remedies 2008. We see that it tries to address the question of the merger applications and the merger control, and the 2008 competition remedies regulation establishes a rule and procedure for reviewing the merger and acquisition in order to assess their potential impact on the competition. It also tries to empower European market to block merger that would significantly reduce competition within the single market of the European Union. And in that respect, we see that it also, meanwhile, try to curb what is called as the antitrust enforcement, and how it is going to enforce and apply and execute the antitrust enforcement. That can only be possible that the regulation endeavors that all anti-competitive agreement and abuse of dominant market position in the European community must be thoroughly investigated, and there should be some kind of a sanctioning regime against those companies who are engaged in such practices by imposing the fines or ordering remedies to restore the competition, to sustain the competition, and to maintain the competition. In that respect, the last objective of the European Commission notice on the competition remedies 2008 appears to be the state aid control, and that state aid control, it tries to implicate that the regulation of 2008 sets out a broad criteria for assessing state aid granted by the European Union member state to businesses. And in that sense, it aims to prevent distortion of the competition that may arise from state subsidies and ensure that the state aid is used to promote common European Union objectives such as innovation, efficiency, consumer protection, competitiveness in matters of business, in matters of trade, in matters of market in European Union, and a sustainable regional development. Then what we see out of the perusal of the entire salient features of 2008 notification, we find generally that the remedies which has been underlined and provided under the 2008 notification happens to be a kind of an improvement. It is coming out of the ponds and shells of not only the merger remedies or merger implementation regulation and the merger regulations. They were primarily the two, that the implementation regulation and the merger regulation, and it has been underpinned into the European Commission on Remedies 2004. What we see that 2008 happens to be a kind of a reform, and that reform will go a long way in the entire functioning of the Treaty on the Functioning of European Union, be that Article 85, be that Article 86 of European Economic Council Regulation, or be that Article 7.1 of the European Council Regulation 2008. We see we see that whether it is Article 85 or 86 of the European Council Regulation, or it is the Treaty on the Functioning of the European Union's Article 101 and 102, or Article 7 of the European Regulation of 2003, we see that whatever has been laid down under the European Union's Commission Notice on Remedies in 2004, and their requirement seems to be improved to a great extent under the European Commission Regulation on Competition Remedies 2008, and it has given a kind of a flip, that it tries to carve out the entire canvas of the remedies. And in 2008, what we find that the European Union's notification on the competition remedies in 2008 tries to see the entire competition remedies in a different perspective, and that perspective is that not only to carve out the divestiture of the existing companies, acquisition of the asset, but it also tried to see that rebranding of the entire notion of the competition remedies, that may be from license to license or from brand to brand. And then we see that these remedies are to be highly valued, and the rebranding and the redesigning of the remedies should be a kind of a constant exercise that has to be taken place. Besides that, the European Union notification on competition remedies 2008 have also tried to see the fix it first approach, or for that matter the structural remedies, or for that matter the behavioral remedies, from a different perspective of identification of the suitable purchaser, and it tried to see that how the divestiture proceeding or the divestment enter into a binding agreement under the competition remedies. Besides that, the European Union's notification on competition remedies 2008 tries to clarifies that the Commission may accept any other kind of a remedy, and that is something very important, and that is something very pleasant to note and underline, that the Commission have heralded a kind of an liberalization, that we are open to see that how other kinds of the remedies can be brought into the fold of the existing competition remedies. And in that reference, we see that the Commission may accept any other kind of the remedies where they will be at least as effective as the divestiture proceedings or the divestiture. Then, in particular, the Commission have hinted that several times they have accepted commitments granting non-discriminatory transparent access to key infrastructure, and thus all those network, key technology, including patent, including know-how, including intellectual property rights, are one of the essential inputs in the entire purview of the competition remedies, meaning thereby that it is something very progressive to locate that European Union notification on Remedies 2008 have opened a large space for the access remedies and intellectual property licensing, and it is amenable to any other kind of the remedies which can be focused, as we have seen, under the European regulations of Article 7's approach, recital 12. We have also seen that to what extent the recital 12 of the European Regulation 2003 happens to change the structure of the undertaking and enhancing the competition remedies. We have also seen the implementation regulation and the merger regulations and the merger remedies, and especially those remedies happens to be very effective. But what can be said that the entire notion and concept of the remedies should go along with the divestiture of the business to a suitable purchaser, and it should remove the link with the competitor. It should be open and embrace other kinds of very novel methods of remedies, including the intellectual property rights, innovations, and licensing. It should have the access to all kinds of the remedies, and it should change the long term exclusive contract and other non divestiture remedies should be equally given attention in the entire prospectus of the access to the remedies. In that sense, we see that neither a clear cut structure nor a behavioral type of remedies will serve the purpose, nor the first fit it first approach happens to be something, a kind of a talismanic cure. But we have to see that how we can find a quasi structural or the quasi behavioral kind of the remedies, and then in that reference what we feel that access to intellectual property has a great promise, be that the copyrighted data, be that the patent, be that the hardware, be that the software, or interoperability of the information. That is also something very effective in matters of digital market. With this, dear learner, I think that the discussion on the competition remedies, extraterritorial application of the competition remedies in the context of European Union, with the detailed discussion on European Union Commission's notice on remedies 2004, which we have already discussed in the previous lecture, but we must have a kind of a broader understanding of the European Union Commission's notice on competition remedies of 2008. And I hope that the understanding of the European Commission notice on competition remedies 2008 will satisfy the entire concept of the competition remedies in terms of European Union. With this, I thank you for dear learner, and conclude my lecture on the European Union on competition remedies, and we'll see that how the experiences of the European Union's competition remedies will be a very helpful guide to see the entire discourse and diametrics of the transnational competition law. With this, I thank you and I wish you a happy learning.